Fundamental hearing procedure.
Yeah, about, from the beginning to the end of the hearing, everything that
Oh,
goes on,
okay.
they talk about.
Somebody listed that. Did we list it wrong?
Well, last week didn't we talk about the legal standards?
She wrote down Mastering Your Central File, Key to Parole Success, Strategy 17.
Yeah, we talked about that last week, I thought.
No, last week we talked about Know Your Hearing Rights. Hello, Joe. Did you have enough coffee?
Okay, C-file review. That's good.
Yeah,
Hey,
exciting. Riveting.
I don't need a teleprompter either, but anyway.
No. I'm your teleprompter. Everything's good.
That's right.
How are you doing? Are you okay? Have you had enough time to drink a bit of coffee?
I've had a few sips.
Okay. Take a few more.
No. Yeah, let's I'm good. I'm good to go.
I'm just bugging you. Why is this important? Why is it in your book? Obviously, it's part of the process, Olson review and that sort of thing in your rights. Let's talk first about why you included it. What was your thought process there?
Well, it's preparation for the incarcerated person. They should be thoroughly know their what's in their C file, and they should be able to review important documents such as the probation officer's report, the appellate review, if there is one, and know the official version of the facts of the crime. Also, that's extremely important because when it comes to talking about the commitment offense, they, their story of it, if you will, shouldn't veer too far off the official version. And if they do, well, that's going to bring up, they're going to say they're minimizing or this or that, not taking full responsibility, lacks insight, any of a number of things. They can also, and the probation officer's report is so important because if depending on the crime, if they don't know the name of the victim, if it was like somebody they didn't know, oftentimes it'll appear in there, unless of course it's a child, or if it was some kind of a crime of sexual assault, sexual nature, then the victim's name is they have a like John Doe kind of name.
Yeah.
So and the probation officer's report is also very important, even at the sentencing phase. Both attorneys get to go over it and correct mistakes by the author of it, which is usually a probation officer, I believe. Correct me if I'm wrong.
That's not correct. But yeah.
I didn't think so. Yeah. So who writes them?
So a couple things about probation officer's report, and that's why you'll see in the comprehensive risk assessment, even the forensic psychologist will rely on the appellate decision affirming,
if there is one, yeah.
If there is one, because it's actually more accurate.
Right.
Couple problems with probation officer's report. There are multiple hearsay documents. So what they've done is they've taken verbatim, without question, without an adversarial process, whatever's written in a police report typically, and they put it into that document. Is the attorney supposed to review that document with their client? Yes. Before the sentencing hearing? Yes. And point out any factual errors before the hearing so that the document itself, when sent to the prison, will include those corrections? Yes. Should your attorney, your trial attorney, include the statement? Sometimes we see the DA write a statement after sentencing and send it to the prison. It's called, it's escaping me right now, but they often do. Sometimes the judges send them into, and defense counsel also has the same invitation to do so and typically does not, because most of the time it's public defenders. They've got hundreds of cases and they're moving on to the next client. But unfortunately, had they done that, they could have made those corrections in the probation officer's report to the multiple hearsay statements that are factually inaccurate or were proved through discovery process during the litigation, disproved at preliminary hearings, motions to suppress, Miranda issues of that nature, where a client maybe has been coerced into giving a testimony that's not accurate. And so, are mistakes corrected at the sentencing? No, not often. Not that often. And the problem that we have then is, by telling clients to just go with the official version, read the probation officer's report, go with the official version. My preference is, don't do that. You don't have to agree with the official version to be found suitable for parole. You don't even have to admit guilt to some of the charges in there. You're arrested, you pled guilty for a certain reason. Sometimes you do it under a thing called a Williams plea. It's escaping me right now. It's escaping. You just say, you know what, whatever it says, I say I did it because I want the deal. Okay. I mean, I literally have a guy that said, I admit to murdering someone after 3 trials, and the evidence is extremely strong in favor of reasonable doubt that he doesn't do it. And I'm currently going to be fighting that next week using the trial transcripts to help him, which is why it's so important for clients to keep those trial transcripts.
Oh, yeah.
I don't know how to tell people to do it, but you get moved, things get lost. Unfortunately, the appellate lawyers just send you the documents back. But so back to the probation officer's report. Is it corrected? Not necessarily. What
Right.
I advise my clients is what actually happened. So if the probation officer says Jimmy the client was doing the shooting while Johnny his friend was doing the driving, and it's actually reversed. Okay, it's whatever. You weren't the shooter. Okay, but you were the driver. It's still really awful. Please just tell the truth. Don't go in and say you did it because the probation officer's report got the names mixed up and nobody bothered to correct it. So again, it's not just be very careful about, pigeonholing, just say it, because then all you're doing is, you don't have to memorize and regurgitate a probation officer's report to be found suitable. And I've had many people, challenge the report. As long as what you're saying doesn't sound completely from outer space, they're typically going to be fine with that. If you've got a rap sheet a mile long and you say, all this stuff happened to me, I was doing all that stuff, but this crime kind of got out of control, but because I'm a gang member, this and that, and the next thing happened, and I went with the deal, or I went with it, or the jury didn't, the jury thought the prosecutor made their case. And sometimes prosecutors make their case based on a little fudging or embellishing of the evidence. Child abusers, okay. If you've got a child rape, child molestation, a lot of times these CPS, these child syndrome experts that come to talk to children, they're extremely leading these children. They're extremely suggestive in the manner in which they conduct these interviews. So yeah, I touched her in the bathtub. Sorry to bring up some people hopefully don't get triggered by this, but I touched her here, I did these different things. But then after the interview and the extremely suggestive interview with the child syndrome expert, you've got this whole mountain of stuff that may or may not have happened, because under the case of People v. Johnson or Jones, I think it is, the Supreme Court came in and said, whatever they say happened means it happened. Even if they recant, even if they said one thing one day, even if they said it later in the day, even if they changed the story, all of a sudden it's at this house and that house, and whatever the child says, even if you can impeach, which a technical impeachment is, well, you said it was a red light, it's actually a green light. For child abuse, it gets extremely complicated. And so you've got just this mismatch of testimony, which basically the court said, don't worry, impeachment is basically as a nullity when it comes to child syndrome expert witness testimony and the child's testimony. And sometimes you don't even have the child on the stand because, oh, it's too traumatic. And so you can't really confront your accuser. And some wacky stuff happens in those cases. And so you have these, it's tricky. I'm kind of going off on a rant, but you've got child molesters are typically quite narcissistic. They lack empathy. That's how they can abuse children. Not all narcissists abuse children. I mean, there's low grade narcissism, but that's what gives them the ability to do that, the grandiosity, the superiority, and all that stuff. And so it gets kind of tricky on that front. I don't know where I was going with that. I got my brain is going too fast. But this topic is kind of it's my topic. I love this topic of don't regurgitate. I know a lot of us, we do say, and if we're really stuck and the story is, I've lost my train of thought, so I'm going this other train of thought. If it's really tricky and the story is just not going to go anywhere, perhaps you could frame it in the eyes of the victim, and at least then you can show that you have empathy for how trauma affects memory and recalling and being suggestible about what happened, and being victimized is extremely complex and how it manifests itself. Eyewitness testimony is the most unreliable testimony when we're talking about gang shootings and stuff like that. So yeah, this topic gets me hot under the collar. But definitely, if you need to refresh your memory on some things, like Joe's saying, victim name, extremely important if it's available. Details, the autopsy showed 5 bullets and you were thinking it was just one, and then you read it and go, oh yeah, I remember now, the gun was unloaded and blah blah blah, we unloaded the gun into the guy or whatever. So it's
Also with
quite important.
stabbings, the guy only remembers one stab, and he did it like 18 times or something.
18 times because he disassociated after the first couple. And so then just, be able to say, I don't remember, it was blacked out, but I have no reason to dispute what's in that report. And if you don't have a reason to dispute it, that's different from, not wanting to remember or being in denial. But that's the problem that I have in general. And I think it's still really important to review the probation officer's report in the face of no other document to see what you're going to be up against at this hearing, and sit down with an attorney and figure out a very good game plan about how you're going to approach this crime if you're saying that's not how this crime went down. And I'm not so sure that it's, well, did the crime go down that way? If you can explain the crime in another way that still makes sense and still sounds awful. It doesn't matter if it happened on State Street, it actually happened on Union Street, and it was, 5 gang members versus 3, or whatever the case was. They found a 9mm, but it was really a sawed-off shotgun, or whatever the case. I mean, that would be sort of a radical change in the evidence, since shotguns fire in create very specific type of injury versus a 9mm. But in any event, whatever it is. So if you can explain things, it says you were found to be the burglar of the house because your fingerprints were on the window, and you go, yeah, my fingerprints were on the window because my mom lived there. Whatever, I don't know, how did the fingerprints get on they got on the window, but not because I went in the house on that day or whatever. And so you can get really caught up in an impression management kind of stilted presentation if you just go in and start regurgitating from the probation report. And Joe knows that I get kind of hot about this issue in general, just because it's extremely tricky. But if you don't know what's in that probation officer's report, you can't help your attorney try to navigate the best approach to this? Do you just paint the picture from the victim's point of view, showing that you have empathy? And I think that's why I got off on a tangent on child abusers, because they can't admit hardly anything. I mean, you start with the child molester from right from prison, you've got all this denial, right? Denial. And why do they take advantage of their victims and things like that? So take it away. I went off on a rant, Joe, and
That's
what
fine. So anyway,
Joe,
yeah, because
Joe is the antithesis of narcissism. He very rarely takes anything personally. So
okay,
that's why I like him.
okay, thank you. Yeah, now there's kind of a batting order, if you will, of documents that have the official version of the facts. The commissioners will always go over the appellate report if that's available, and that's because that's taken from the trial and everything that was said and presented at the trial. And
Exactly.
then the probation officer's report, and then if those two are missing, then police reports, and that's definitely hearsay. I mean, that was done, it probably in a rush, of course, because police have so much work. They're overworked and underpaid, of course, uh, to protect your life and my life all the time. And I respect police officers very much. But that being said,
They're human. I mean,
irrelevant,
mistakes get made. Things,
to
they
our
go
case.
back to their shop after 8-hour shift and try and recollect a few things and stuff like that.
Yeah,
So
there you go.
yeah,
So, anyways, that's kind of the pecking order, the batting order, if you will, the food chain, whatever you want to call it, and
mhm.
of and that's the basis of the facts that the commissioners are going to go off of. So, uh, who's ever reviewing their C file, you want to get it right and make sure the details are right, and the major things, not was the driver wearing a red tie or a blue tie when he or she went through the intersection,
Mhm.
it doesn't matter. But was the light red or was the light green when the driver went through the intersection? Those are the highly relevant facts that, when those come into question, the hearing gets complicated.
It gets complicated. Yeah, it
Yeah,
does. And so that's why you really need to have had this sorted out with an attorney that sits down and go, okay, tell me what happened
of course. Yeah.
on the day of the life crime or the events leading up to the life crime, and really go over that to the best of your ability with the attorney, so the attorney knows what's coming. Because I'll tell you, it's really hard to, you know, tell the truth, the whole truth, and nothing but the truth if you're making stuff up because you want to be granted parole, and then you're going to be found to be, you know, a
No.
impression management type of thing, which is easy for narcissists to do. The impression management is just, you know, not easy for people that are actually authentic. Now, remember, antisocial personality disorder as well, and so has that deceptive, manipulative quality to it as well. And so that's another reason why the commissioners and their spidey sense is pretty sharp at noticing whether you're just telling them what they want to hear, what you think they want to hear, because that's, another reason to just look at that document or ask your attorney to send it to you at a minimum.
Yeah, I think who was it who told me? Gardner. Well, he didn't tell me, but he said in the hearing that we didn't get all these gray hairs for nothing. We're pretty smart and we know when you're lying.
Yeah. And I've had a client denied 5 years because he said he was the shooter instead of the lookout, because he came
Oh
across
my gosh.
extremely not genuine. They could see through the impression management. He had no insight into why he would shoot someone, because he didn't shoot someone. He didn't have the insight. And he just said the guys on the yard told him, say you're the shooter and get on with it. But you
Oof.
can't, it's extremely difficult. And also, unless you're a complete psychopath, you're not going to be able to pull that lie off that well.
Oh man. Isn't it, isn't the truth so much easier in the long run?
Sometimes, I mean, but you have commissioners that just refuse to follow the law, and they're just so, tunnel vision about the probation officer says you did it, so you must have done it. Like sometimes it's just unfathomable that they say that. It just lacks such common sense about how the real world works in trials. But not all commissioners. There's a lot of extremely good commissioners that understand what's going on, but you have to have a lawyer present that to them. If you don't, they'll just steamroll right over you, say you minimize, say there's too much discrepancy in the report. And when they do that, sometimes I'm like, good grief, and if it's really bad and resulted in a denial and there's no other reason, I challenge that. But usually there's other things going on if they're going to deny parole, because I know they can't just rely on you not saying that you didn't do it. I just had my old client, he just got granted parole. He's 87. He's been claiming innocence for 50 years. Nobody would go with the law in Ray Swanigan, in Ray Shaputis, Supreme Court Penal Code 5011 to say, whatever. Unfortunately, he had an unfortunate incident in 2017 where he held up his cane to defend himself. The officer said he used it in a more offensive manner, but who knows? 50 years. I filed a complete brief for him.
Did he have a B number, by the way? Or a C number?
A or B? B.
B? Yeah, I've had like maybe one or two of those my whole time.
Oh, yeah, B.
Wow.
And I fought really hard for him at the last hearing, but he just,
What?
Unfortunately for him.
He got denied?
Yeah, he got denied, and then we just looked him up. And he just got granted under this exact same presentation. But unfortunately, here's the thing. He said he didn't do it. There was some evidence that said he might have. There was a witness, a cooperating witness for the government, and that always gets really sketchy because there's some unethical prosecutors. Not all of them, but there's a lot of them, just like everybody else, that will just go with whatever, say whatever, say.
I don't know. Elizabeth, hey, you're right.
Believe me, I've had him coach witnesses to lie, and we have it on tape. But that's a whole different story.
You know what? That just gets my blood boiling,
Oh, it's just standard operating procedure.
I know, but
not
still.
for all of them. It's just like humans.
No, of course not all of them.
But there's some
the ones that do. That is just so egregious.
Can't take it personal. Just more narcissism.
How can they sleep at night?
Narcissism is because they're narcissistic. They don't care. Win at all costs. But
I digress. But weren't we taught in law school that the public defender should advocate zealously on behalf of her client, and the prosecutor should seek justice, right?
Well, but they're human, right? And their egos are flaming out, so they can't get control of that. But it's just human nature. We're not all robots. We're not all perfectly humble human beings.
Of course.
And prosecutors lack a lot of empathy. So
I think that's why they're good for the job, probably.
They're excellent for the job. I mean, you have to be somewhat you've seen them just walled off because you have clients, they've done shitty things, okay, but their families are suffering too, but they don't care. No. And they don't care if they're railroading someone. They do. Not all of them, but in general, they follow orders from the top of the command chain, and the top of the command chain needs to be reelected. But anyway, I've digressed into this deep, dark subject.
Yes.
The darkness of it all, but it's just not as straightforward. But yeah, so my client, Mr. So-and-so, it doesn't really matter. unfortunately, okay, so let's go back to my original point. The probation officer's report said you did these things, different things, and you say, I didn't do these different things. Don't rest on your laurels of my rights and fail to do any programming. Do everything else. And that's the reason why that client was being denied for 50 years. He refused to even do the bare minimum of 12-step programming and to learn about his alcoholism and drug addiction, which he did have, which so you could build your entire presentation on all this other stuff that you did do to where the life crime itself isn't really a major focus, because all you want to do is be able to identify and have self-awareness into character defects. And again, that client was quite narcissistic. So he lacked self-awareness. He lacked the ability to empathize. He's superior, doesn't need all that stuff, grandiosity and this and that. And he just couldn't do it. And so, again, the narcissism can look at themselves. Very hard to take a good hard look at yourself and admit mistakes, admit any of that. And that may have been playing out for him as well. Because I saw evidence that there's always evidence that he did it. Otherwise, the jury wouldn't have had anything to go on. But sometimes there's a lot of sensational stuff that happens at trial, as I just explained, and more. So, yeah, I think you're right, Joe. This is really, really important to go over your central file as a strategy, and your loved ones that don't do it, or they go in the room and they, because of their codependency or their low self-esteem, they just say, the officer says, oh, well, just, what do you want to look at? It's like, I want to look at the whole thing, actually, because you're just going to click around and everything. It's like, no, I want to look at all of my 115s to make sure that there's not something in there that should have been removed for whatever reason. I want to look at all of my certificates, which again, isn't that helpful because not all the certificates are in there for whatever reason. They're in bits and not, I don't know why, who knows. You want to look at all of your legal documents to make sure that everything's copacetic. Look at your abstract of judgment, make sure in the parole, make sure you get a copy of your previous risk assessment. If you lost track of it due to transfer, and your loved ones are allowed to ask for copies. And if you don't get copies, they need to be unfortunately called out. I mean, and then we try and call them out and nothing happens and we end up sending the documents anyway. So
Yeah, and I heard, well, with regard to the probation officer's report, I've heard numerous times that staff refuses to print that out for the incarcerated person.
I
They say
know.
it's confidential or
Oh,
something.
it's bullshit. Then
I
why isn't it
know,
in the confidential
of course it
file?
is. Yeah, yeah, exactly. So just, you know what? Just tell your
It's just
attorney that they
officers
refuse to
not
print it
knowing
out,
yeah.
and there's the U.S. mail.
Yeah, just tell your attorney. The attorney sends you a copy. Sorry about that, Joe. Yeah. The officers, they're not lawyers and they don't know. They kind of make the rule up based on some other rule and they make assumptions and then yeah.
Thank
And
you.
then just
Thank
instead
you.
of maybe fighting with the officer, just say, look,
No, never. In fact, I had
send me the
one guy
report.
who almost got, well, actually, he did get written up for a 115 because he got into an argument with the staff person who wouldn't print out his probation officer's report. And that kind of sucks. I mean, it shows a sense of entitlement. Just, you know what? Relax and tell your attorney. That's all you got to do.
Yeah. I mean, he should fight that 115 anyway to bring it to the
he did.
He should bring it to the attention that I'm supposed to be able to get, because I always tell them, ask them, show them the rule, talk about the case. And if they still don't do it, just stop, send me a letter, and I'll get something in the mail to you.
Yeah,
With the
exactly.
81-cent stamp or whatever it is now.
Yeah, keep it simple,
Yeah, just stay out of every harm's way. And I just tell them, even like, don't even be a freaking Mac rep or whatever, because it's
Oh,
just, you're just attracting controversy there too. Don't be a facilitator of the group.
no?
Why? Because you're just
Why?
going to have to deal with people.
Well, true. Well, but I think being a facilitator, on the other hand, also shows a leadership position, and you're not just
Well,
sitting
I
there being,
know.
listening to the group. You have to participate, and so I
I
think there's
know.
pros and cons. You
But
got to weigh the.
I agree with you on that. Totally.
Mhm.
Like, but
Okay.
just people get in your face and everything.
Oh
It's like,
yeah.
oh God. Because then
Well,
they
then
say,
you
oh,
can use. You know what? Practice your coping skills. Then.
it's hard with some people,
Oh,
especially if you're dealing with narcissists who just have lack self-awareness, lack empathy, and are
I
going to get in
cannot
your
disagree.
face, argue with you, gaslight you, and then you're in this crazy making conversation. You can't get out of it.
Yeah.
But um, what else is there about central file review? Looking for
Well,
the names of the
there's
victims.
sections. You know what I would emphasize too? Navigating the C file review, because many persons are not computer savvy.
Mm,
So in the upper right hand corner, there's a table of contents. And if you can't find it, I would ask the
ask.
assistant there
Yeah,
to help
yeah.
you. And then it's very easy because everything's in sections, from, I don't have a copy of that in front of me, but from case summary, I believe, and then there's disciplines, parole. Just click on those. Like parole has all the documents. It should have some of the documents at least you previously submitted if you've had a hearing already uh, in that section. And it has like past hearings, records, uh, decisions, uh, in that section. And that obviously, I think somebody needs to not only read their decision in the C file review if they haven't done so already, but hopefully they've read it in the days after their previous denial, knows what the heck it says, and can be able to tell somebody what it says, and then they address all those factors of why they were previously denied. So it's very important to have the transcript uh,
Yeah.
days, I mean, not days, years ahead actually of the C file review, because uh, that's feedback for what you need to do going forward to the next hearing, whether it's in 18 months, 3 years, or 5, 7, whatever it is. You got
Mm-hmm.
to address those factors, and if you don't address them, don't don't expect to be going to the gate anytime soon.
Mm-hmm. Mm-hmm. Mm-hmm.
So yeah, know that decision. Uh, and like you said, know all the disciplines. At least going back 10 years. I
Right.
don't think. I mean more, of course, but that's at a minimum. I think to know your disciplines going back 10 years. Why why, what happened, and taking responsibility for it, um, and moving on.
For sure. For sure. Totally agree. That's pretty much it for central file review. I would say too, like if you get like a shitty central file review from the office, sorry, like, just a pro forma type of, here you are, sit in front of the computer, or, you can't sit in front of the computer and scroll through anything. Just tell me what you want to look at kind of attitude, or you ask for copies and that doesn't happen. Like Joe said, just step away, try to address it. And if they still give you grief, then just stop.
Hmm.
Stop, and you can address it the proper way, either a 602 if you feel like you're protected from retaliation in that aspect from the officers, and or ask your lawyer to, like I said, either make copies, or if you really need to have this remedied, via some grievance process because it's out of control in your yard or at that prison, then perhaps, some help filing a grievance on that after the fact, but not the most important thing for you to be helping everybody else, because you do have that attorney who has access to that file that can help you at least get, because some of the stuff you don't need to look at. You really don't. Add seg placements. Okay, just be honest with the lawyer about when you were in ad seg and why, so
Yeah.
that they know what's coming. Miscellaneous, if you filed a bunch of 602s that are just totally off the wall, you probably should tell your attorney that as well, because some of these deputy commissioners start deep diving there
Yeah.
on some of your dietary issues and stuff where you say you're Jewish and you're really not Jewish because you just want to get the better meal and all that, which brings up some discrimination. But anyway, we don't want to go there. So, or Muslim or whatever, you want the special diet thing, but then you're really not a practicing Muslim or practicing Jew or whatever. I've seen that a lot. So you just have to bring that to the attention, because that's antisocial behavior and narcissistic, right? Sense of
Mhm.
entitlement, the superiority, the arrogance about, I get special treatment regardless of whether the rule applies to me. The rules don't apply to me. That's another one. Rules don't apply to me. So,
Or this one does and this one doesn't.
yeah, pick and choose. We know that.
It's
That
not a
always happens.
cafeteria.
I treat it like a cafeteria.
Okay.
No.
One other thing too that happens occasionally, maybe it happens more often than occasionally, but there's good counselors and there's bad counselors. Sometimes I hear that the counselor has them sign the form that they've seen it before the meeting, and then they don't get a full review. Like something happens, they're called out, and they go back, and the counselor says, for whatever reason, I'm too busy, blah, blah, blah. And they never get a full C file review. So
Right.
you try to help them in the hearing, and you tell the commissioner up front that they didn't get an adequate C file review. And the commissioner says, well, we got this here. He signed it on such and such a date. And did you sign it? Yeah. Yes. Yeah. He asked me to sign it, so I signed it.
Mm.
That happens occasionally. And actually, one time I think it was a fairly new commissioner. I can't remember, but he or she called legal in Sacramento, and they said, well, you have a signed copy of that form in the file. So yeah, they got that was an adequate C file review because there's a signed, he signed it. So be very careful. Don't sign it ahead of time. Sign. I mean, if possible. Sometimes
I mean,
they'll
it's
insist
not
you sign it.
possible sometimes because you're
Right.
just in danger, because
Yeah.
you get a bad attitude officer and you just don't want to go there too much
No.
because
No.
it's tricky.
It is tricky. I think the whole process, I mean, it has its landmines everywhere.
Yeah. Yeah.
And that's
You just
another one
have
you
to
don't want to
keep
fall in. You don't want to argue with staff. Just
right.
be cool. And tell the proper people. And you know what? Isn't that the pro-social way, if you will, of doing it? And that's the person you have to become. I mean, you wouldn't
Is
go into
extremely humble to authority figures, even if they're wrong.
yeah, there you go.
Right.
Yeah, it's not important to be right. It's important to get along.
Exactly. Especially when you're trying to get paroled. It's just more important for that.
It's so difficult alone, everything being even, but having these obstacles, you don't want to create any more obstacles than you already have.
Right. That's right. And just kind of suck it up and go, okay, well, I want to go home. I'll just let that officer do his thing.
Yeah. And the officer wants to go home too at night to his family. So, you know what,
and let some other inmate battle that officer, because they are going to.
Of course. Yeah.
Mm-hmm. They are going to. What else? Anything else on this topic?
Just get it, hopefully with enough time in preparation for the hearing that if there are any problems that you're able to tell your lawyer about it.
Right.
Your fine lawyer.
Oh, yeah. That's right.
And
Well,
you can get the book, 36 Strategies of Suitability. It's available on Amazon. I believe it's $19.95. Or if you
please. Yes. Please, please,
have
please.
the privilege of having me as your attorney, you might get a copy to help you out.
He
Who
might help
knows?
you out. You never know.
Yeah.
And I think that my wonderful assistant, she put the link as well for the
Oh,
book in the
thank you.
program description for you, Joe.
Great. Thank you.
You got it. The royalties are going to be flooding in here any minute.
Okay.
Okay, just joking. Let's wrap it up. What's next? What's next? What's next? Strategy 18, I think.
Yeah. That's the one, the legal standards for suitability. That goes more to, I believe, the case law and what the Supreme Court says. And
Okay.
yeah,
Beautiful. I love case law.
I know. You're a great appellate attorney. That's what rumor has it.
No, I'm really not.
Oh, come on.
I do misdemeanor appeals. They're not rocket science.
Well, people need those as well. So good for you that you do that work.
Well, yeah, that's all right. Okay, let's wrap it up. It's not that exciting of a topic, but it's exciting enough. We made it as exciting as we could. Next week will be great. Lots of different people love the law for some reason. I don't know why.
Well, that's why we went to law school.
There's a DA, a former DA. She has a channel on YouTube. She's got like 750,000 subscribers, and
What?
she dissects legally all of the sensational trials of actors or any of these sensational, whatever, not just actors, but just these infamous kinds of trials and court
Yeah, people in the
cases.
public eye.
Thanks. Yeah, no, thank you, Joe.
Right, sure.
In a simple way. Anyway, she's extremely popular. She's very opinionated. She's easy to listen to. She's like no nonsense. She just goes on there. She live streams. The most popular live streamer in some ways too. Very, very interesting. I don't have time to listen to her otherwise, and I don't really care for the sensational trials in the public. The last one I ever did was probably OJ, perhaps, and that was actually quite interesting. But I was in law school, so I thought it was interesting.
Yeah, that's when I was in law school too.
Oh, okay, great.
Yeah, we must have similar bar numbers.
It's 202.
Okay, 221.
Oh,
All right.
okay. So you started later.
Yeah.
You started in 1997 or something, 1996,
Yeah, it
97.
probably took me longer to pass the bar than you, so.
Oh, okay. I went to law school for 4 years
Me too.
and it took me one time.
Oh, fantastic. Congratulations.
Yeah, I'm a good test taker more than anything. I'm not the brightest, believe me. I squeaked into law school under a very low the lowest possible LSAT. So
Wow.
not the brightest. No,
No. You are one of the more sharper tools in the shed.
I
You are,
don't,
Elizabeth.
I don't know.
If you can listen to yourself at the BPH meetings on Monday, you're pretty sharp. I'm always impressed.
Maybe. I
Yeah,
don't know.
you are.
Sometimes I just think I sound like a
In my
blowhard.
humble opinion. In my humble opinion.
Thank you, Joe. Thank you. Thank you. You're my biggest fan. So I will see you next week. I'll see you Monday, I guess, at the meeting.
That's right. Okay, very good. All right, you have a good week and a good rest of the day.
Yeah, you too. Thank you so much for coming on. Oh, here's Mike tuning in late.
Oh my gosh.
I'll let him in, but I got to get going.
Okay.
But hang on, let's say hi to him. Let's see if he can connect.
Okay.
We'll yell at him. I'm going to end the stream. And then if I'm going to end the stream. Thanks for everybody tuning in. Please share with other family members if you know anyone who needs help in this area. Joe and I can be easily found on the internet and in the listing here. And I'm going to end. Let's see if he turns up.